The ICF Training and Technical Assistance Team is honored to welcome you to this California Housing and Community Development Community Workshop offered through the Emergency Solutions Grant Coronavirus Relief Consulting and Staffing Services Contract. I am Chris Pitcher from ICF, and I'll be hosting today's session. Today's training session is part of our new and non-traditional provider workshop series, where today we will be discussing ESG and ESG-CV, rapid rehousing. It is my pleasure to hand the presentation to our first presenter, Mike Thomas. Mike, take it away.
Thank you, Chris. So I am Mike Thomas. I use he, him pronouns. I am a technical assistance provider with ICF. And before we jump in, I will let my colleague Gordon introduce himself as well. We will be presenting together today.
Good morning, everyone. My name is Gordon Levine. My pronouns are he, him. I'm also a technical assistance provider with ICF. I come to you most recently from the Louisiana Balance of State Continuum of Care, where I was its inaugural COC manager, and before that, the state of Wisconsin, where I ran its alphabet soup of HUD programs, including ESG.
All right. And so as Chris mentioned, we are going to be talking about rapid rehousing today. We have a lot of material to cover, so we're going to move through some of it pretty quickly, and we will go ahead and dive right in. So this is what the day is going to look like for this presentation. So in hour one, and we might have to be a little flexible with the hour one, hour two delineation, but generally in hour one, we are going to talk about an overview of rapid rehousing. So the requirements, regulations, things like that. Then we are going to talk about COVID-19 waivers and alternative requirements that apply to certain ESG allocations. Then we will take a quick intermission. Moving into hour two, we will talk about best practices in rapid rehousing program design. Then we will do what we call our lightning round, where we will ask some questions to see what we've learned. And then we will have time for question and answer, hopefully at the end. So a reminder on where we're focusing on these. If any of you have attended previous sessions, you'll have seen this before, but we are focusing on the subrecipient and sub-subrecipient levels for this training. So the ESG money comes from HUD, and then it goes to California HCD. They are the primary recipient, and then they subgrant that to subrecipients, and then that often gets sub-subgranted below that level as well. So we are focusing on those bottom two levels, subrecipients and sub-subrecipients of California HCD ESG funding. I'm not going to go through all of these in detail, but we like to throw up this slide on the alphabet soup that we like to use. Gordon used that term before, and it applies across all federal funding. So these are some of the common ones we're going to use today. ESG is the Emergency Solutions Grants Program. ESG-CV is the same program, but an allocation specifically through the CARES Act. RRH is rapid rehousing. If you see FY, that's fiscal year. You all know California HCD. We'll call them CAHCD here. HUD is the Department of Housing and Urban Development. The recipient, in this case, is HCD. They get ESG money straight from HUD. Subrecipients and sub-subrecipients fall below that. And then an UGLUG is a unit of general local government. Sorry. And then one final note on context. So we'll talk about regulations and compliance. When we do that, we just want to bear in mind that there are many layers to that. So there's the federal uniform guidance that dictates how costs are handled across federal programs. Then there's the ESG interim rule. The ESG interim rule makes some slight tightening to what the federal uniform guidance says for the ESG program. And then under that, you've got HUD guidance. So that's HUD answers to ask a question submissions, frequently asked questions that they post on the website. And in this context, also the ESG-CV waivers, which we will talk about. And then below that, there's local policies. So in this case, most specifically, that is probably going to be written standards and requirements from California HCD. Programs must be compliant with all of this to be fully compliant. So we just like to make sure everyone has that context. And I'm going to turn it over to Gordon to get us started on rapid rehousing basics.
All right, well, let's move into rapid rehousing basics. Next slide, please. So what is rapid rehousing? In a nutshell, rapid rehousing, or RRH, is designed to accomplish two key objectives. Number one, helping people experiencing homelessness move as quickly as possible into permanent housing. And permanent housing is defined as a number of different things. It is inclusive of rapid rehousing, but it also includes permanent supportive housing and housing that exists as a participant lease without a subsidy. And two, helping them achieve stability in that housing, which again means is inclusive of achieving stability in rapid rehousing. Next slide, please.
I apologize. I had a technical
okay.
difficulty there. I'm going to need to go back several slides. Give me a second.
Take your
Thanks.
time. I saw my next 20 minutes flash before my eyes. It was incredible. All right, there we go. Next slide. Thank you, I appreciate it. So eligible participants, we're really talking about two categories of people. These categories are defined by HUD under the hearth homelessness definition or definition of homelessness. Category 1, which is literal homelessness, and category 2, which is people who are fleeing or attempting to flee domestic violence. Under literal homelessness, we're talking about an individual person or a family who or that lacks a fixed regular nighttime residence, meaning they have a primary nighttime residence that is a public or private place not meant for human habitation, or they are living in a publicly or privately operated shelter designed to provide temporary living arrangements, which includes congregate and non-congregate shelters, transitional housing, and hotels and motels paid for by charitable organizations or government programs, or people who are exiting an institution like a prison, a jail, a hospital, or an institution for mental health, where they have resided for 90 days or fewer, and before they entered that facility, they resided as their primary nighttime residence in one of those other locations mentioned in the literal homelessness definition. If you want to boil that down, it's a place not meant for human habitation, like on the streets, or in a shelter, or in a park, or in a car, or exiting an institution and they entered the institution from one of those other places and they were in that institution for 90 days or fewer. Fleeing domestic violence is any individual or family who or that is fleeing or attempting to flee domestic violence, and they have no other identified permanent residence, and they lack the support networks to obtain other permanent housing. To be eligible for ESG rapid rehousing, people who are fleeing domestic violence must also meet the requirements of the literal homelessness definition, as described on the left side of the screen. Fleeing domestic violence is also understood, by which I mean does, include people who are survivors of human trafficking. It also includes dating violence, stalking, and domestic violence, dating violence, sexual assault, and stalking. Next slide, please. Eligible activities for ESG Rapid really are divided into two categories: short to medium term, or short and medium term rental assistance. Short meaning rental assistance that lasts for up to 3 months, medium term meaning rental assistance that lasts between 4 and 24 months. The average is much lower than 24 months, and a one-time payment of up to 6 months of rental arrears. All of that together cannot exceed 24 months. And housing relocation and stabilization services, which includes a broad range of things under financial assistance and other services. This is where you would locate, for example, case management. We're going to talk more about that later. Next slide, please. Big note on ESG-CV, that is to say ESG funded under either of the two tranches of ESG designed to prepare, prevent, or respond to COVID-19 that was funded under the CARES Act. HUD has released waivers and alternative requirements for ESG-CV and for federal and for annual ESG funded under federal funding year FY 2020 and earlier, when the annual ESG funds are used to prevent, prepare, and respond to COVID-19. You will sometimes hear us refer to that as the PPR tieback, prevent, prepare, and respond to. Alternative requirements and additional eligible activities for those specific funding streams will be detailed in a later presentation. They're not included today. Next slide, please. Back over to you, Mike.
Thank you, Gordon. All right, so let's jump into ESG rental assistance. So we talked a little bit previously about some of the parameters around that. So you can have short and medium-term rental assistance, and it can be implemented using either of the models that you see below. So there's tenant-based and there's project-based. In tenant-based rental assistance, this is the one that many programs are most familiar with. Program participants select a housing unit to live in, and they receive rental assistance there. It may be limited to a specific service area based on provider capacity. So client choice is important. Clients should have a choice in where they live. But it's also important to note that, you know, a program operating in, say, Southern California is probably not going to have the capacity to serve clients effectively if they move all the way to Northern California. And so they can limit people to a specified area based on capacity. In project-based rental assistance, recipients or subrecipients identify permanent housing units that meet the ESG requirements and then enter into a rental assistance agreement with the owner of those units so that they can reserve the units and then subsidize rent so that eligible participants have access to the units. So it's a slightly different model, but either of these is eligible under the ESG program interim rule. Another important concept to talk about under rental assistance is the concept of gross rent, because there are a couple of tests that units have to pass that we're going to talk about directly after this, but the key number there is gross rent. So it's not just the contract rental amount. It is the contract rental amount plus any occupancy fees, and that does not include late fees or pet fees. Those cannot be included, but any other occupancy fees, and that generally means a fee that is included in the lease and is charged to every leaseholder across the property base that the landlord manages. So that's included in gross rent. And then utility allowance. So there's a monthly utility allowance, and that's established by the local public housing authority. Each housing authority has a schedule that you can look up that details what the utility allowance is for that area. When calculating gross rent, the only utilities that go into gross rent are the ones that are not included in the lease. So if water, for instance, is included in the lease, you would not add the water amount from the public housing authority into gross rent. All of these things, though, have to be added together to come up with this number, gross rent, which we use for the following purposes. The first of those is for the fair market rent comparison. So fair market rent are values that are set annually by HUD. Every county and metropolitan service area has its own fair market rent, and those can be looked up on the HUD website. Fair market rent assessments are very straightforward. Gross rent cannot exceed fair market rent. So you calculate what we just talked about on the previous slide, and the amount you come up with there cannot exceed the fair market rent for a unit of the size as posted on HUD's website for fair market rent amounts. The next concept is rent reasonableness. This is another comparison that must be done. This one is not quite as straightforward. There's some local variation sometimes, but ESG recipients and subrecipients establish standards for rent reasonableness, and then subrecipients determine whether the units meet rent reasonableness. Rent reasonableness is calculated using local, comparable, unsubsidized units. It is not a fixed value, and it will differ between units. So you're looking at comparable units in the same neighborhood, of the same age. There's a number of factors. Rent reasonableness is more complex than FMR, but there are ways to simplify it for the recipient and for subrecipient staff. And I think you will probably see more guidance in the future coming down about rent reasonableness. So keep an eye out for that if you're a recipient of ESG funding. Gross rent cannot exceed the reasonable rent amount as established by the written policy. So when a reasonable rent amount is calculated based on the written policy that you are working from, gross rent cannot exceed that amount. When we think about rent reasonableness, there are some key things to keep in mind here. So when we think about the concept of reasonable, the gross rent must be reasonable, meaning that it is less than or equal to other comparable unassisted units in the area. Reasonable should take into account unit location, quality, size, type, age, amenities, and maintenance and utilities provided by the owner. It's important to note here that we understand when we say unit quality, that can be kind of vague, but that language is specifically from HUD, and it is kind of up to the subrecipient to make a judgment call on that. The recipient determines what documentation is required to meet the rent reasonableness standard in its written policies and procedures. So the important note there, California HCD is the recipient, and they can ultimately determine what is required for documenting this in terms of compliance. So requirements for rapid rehousing for the two things we just talked about. And I'm also going to make an important note here on rental arrears. Rental arrears payments are separate from rental assistance. When a subrecipient provides a one-time rental arrears payment without any other rental assistance, fair market rent and rent reasonableness are not required. I'm going to repeat that because it is often an area of confusion. If the participant is only receiving a rental arrears payment without any other rental assistance, fair market rent and rent reasonableness standards do not apply. So when an agency is providing rental assistance, so monthly rental payments, both of these are required. When they're providing rental assistance and rental arrears, these are both required. When they're providing rental assistance and any other services under ESG, both are required. If they are providing only rental arrears, then these are not required. If they're providing only housing relocation and or stabilization services, but no rental assistance, then these are not required. However, if an agency is doing that and then they later provide rental assistance based on that household's needs, then both of these do become required. So the bottom line here is that if any rental assistance, meaning monthly rental payments to subsidize the household's rent, are being made, then both of these standards apply, both FMR and rent reasonableness. And so here's some information in terms of certification and recertification timing for making these comparisons. The initial certification showing that a unit meets these standards must be made before the initial lease is executed. And then it must be recertified before a lease renewal is executed. If the existing participant moves to a new unit, then before that new lease is executed. When the project's written policy requires it. Some projects have written policies that require this to be recertified in different time intervals. They must follow their own written policies. And then certain other rent reasonableness assessment triggers. So I'm going to list those out here. So before any increase in rent to the owner, if the owner increases the rental amount, then you must verify that both of these standards are met. If there is a 10% decrease in the published fair market rent that goes into effect 60 days before or within 60 days before the contract anniversary, or the final note, if directed by HUD. So basically, if HUD tells you that this needs to be done, it needs to be done. And another important note here, subrecipients need to develop written policies for fair market rent and rent reasonableness certification and recertification. Gordon and I talk about this a lot in our trainings. There must be written policies to address when these standards are evaluated. And I will turn it back over to Gordon to talk about rental assistance agreements.
Thank you very much. Yeah, Mike is absolutely correct. My hobby horse is written policies and procedures. You really should, at a project level, as the best practices for rapid rehousing for any ESG program, have a set of policies and procedures that specifically define the operations of your project, how you implement everything from fair market rent and rapid rehousing to recertifications and so on, just so both of you have something to reference as you go about your daily business of implementation, and so that when new staff come on board, there is continuity of services between staff. Just putting in a plug there. Moving on to rental assistance agreement standards. Rental assistance can only be provided when a rental assistance agreement is in place between the recipient or the subrecipient or the subrecipient and the property owner. The agreement has to set forth the terms under which rental assistance will be provided, including at a minimum the items that are listed on the slide. Some of these are specific to tenant-based rental assistance or TBRA. Some are specific to project-based rental assistance or PBRA. Some of them are general to both. So for both, it requires a provision requiring the owner to give the recipient, subrecipient, or subrecipient a copy of any notice to the program participant to vacate the housing unit or any complaint used under state or local law to commence an eviction action against the program participant. In other words, the program provider, the ESG provider, needs to be kept on the loop if the homeowner is attempting to censure or evict the participant. In addition to which, the same payment due date, grace period, and late payment penalty requirements as the program participant's lease need to be applied to the rental assistance agreement. Under TDRA, recipients, subrecipients, and subs should establish the term of the rental assistance agreement for the period of time they anticipate providing assistance. There is no requirement for the time period of the rental assistance agreement to coincide with the term of the lease. Generally speaking, what this means is that for 12 months lease, that it is okay, for example, for a 12-month lease to have a 3-month or a 6-month rental assistance agreement attached to it. The rental assistance agreement does not need to match or balloon to fit the duration of the lease. In addition, the rental assistance agreements must automatically terminate if the participant moves out, the lease terminates and is not renewed, or the participant becomes ineligible for ESG assistance. On the project-based rental assistance side, the initial term of the rental assistance agreement must be 1 year, 12 months. When a new program participant moves into an assistant unit, the rental assistance agreement may be extended to cover the initial term of the lease. If the participant's lease is renewed, the rental assistance agreement may be renewed up to the maximum number of months for which the participant is eligible for assistance. And finally, the rental assistance agreement may cover 1 unit or more than 1 unit in the same building. Next slide, please. Rental assistance agreement standards. While not explicitly required, rental assistance agreements are strongly encouraged. We strongly encourage you to ensure that your agreements contain provisions for the following. The type of rental assistance being provided, meaning either tenant or project-based. Details regarding late payments, when payments are late, what happens when payments are late, what is the grace there, etc. Program participant share of rent, if applicable. This one's critically important. Everybody wants to make sure that they understand what money is coming from whom and in what direction. And finally, details regarding termination, which incidentally must be compliant with Violence Against Women Act standards, which are outside the scope of this presentation, but which are in place for ESG. Next slide, please. Special note on rental arrears. Even when the assistance is solely for arrears, a rental assistance agreement is required. For the payment of rental arrears, the agreement should provide the amount paid by the recipient, subrecipient, or sub-subrecipient, include the number of months of arrears paid, and any other terms and conditions of the payment. And the agreement should reflect the evidence or documentation used to justify that the arrears are an eligible payment. Next slide, please. Lease standards. For lease agreements, each program participant who is receiving rental assistance must have a legally binding written lease for the unit. Though note that when the assistance is solely for arrears, an oral lease agreement may be accepted in the place of a written lease if the agreement gives the program participant an enforceable leasehold interest under state law and the agreement and rent owed are sufficiently documented by the owner's financial records, rent ledgers, or canceled checks. In other words, an oral agreement may work if it works for your state law and if it creates an enforceable situation for the rental assistance agreement. The lease must be between the program participant and the property owner or property owner's agent. For project-based rental assistance, the initial lease term must be for a year. For tenant-based rental assistance, there is no requirement for the initial lease term. It can be of any duration that fits within the short to medium term level. Next, please. Next slide, please. Next, please. Other rental assistance requirements. Except for rental arrears, ESG rental assistance may not be used with other public rental subsidies or the Uniform Relocation Assistance and Real Property Acquisition Act, or the URA assistance. The recipient or subrecipient is solely responsible for paying late payment penalties that it incurs with non-ESG funds. That it incurs. Next slide, please. Back over to you, Mike.
All right, thank you. So now we'll jump into the housing relocation and stabilization services. So under financial assistance, these are the things that are eligible under ESG. You've got moving costs, rent application fees, security deposits, which can be equal to up to 2 months rent. Although a note here, there are alternative requirements for this under ESG-CV and annual ESG used for PPR, as we talked about before. So we're going to talk about that a little later. You can pay last month's rent, which can be equal up to the amount of 1 month's rent. utility deposits, and utility payments. And then in the services category, eligible services are housing search and placement, housing stability case management, mediation, legal services, and credit repair. We're going to go into a little more detail in the next couple of slides on housing search and placement and housing stability case management, because there's a number of things that fall under those categories. So for housing search and placement, we're talking about these items. So it's assessment of barriers, needs, and preferences, development of an action plan to locate housing, housing search, outreach and negotiation with owners, assistance with rental applications and understanding leases, determining compliance with habitability standards, lead-based paint, and rent reasonableness, obtaining utilities and arranging move-in, and ESG annual limits. It limits pre-housing assistance to 30 days. ESG-CV extends it to 60 days. So that's an important note. We're going to talk about those waivers a little more later. Under housing stability case management, entry through the coordinated entry system, developing an action plan to locate housing, referring for community-based services, coordinating services, verifying and documenting eligibility, develop housing and service plans to maintain housing, and then reevaluating progress for the participants. So as you can see, there's a number of things eligible under both of those categories. And you can also reference that in the ESG program interim rule, but there are a number of activities available under those two lines. So some special notes here on mediation, legal services, and credit repair. Oh, wait, I'm sorry. This is back to you, Gordon. I almost took your slide.
Sorry about that. I lost my mute button. So lots of stuff there. Special notes. Mediation is eligible but generally not used with rapid rehousing. It is only eligible to resolve issues between participant and owner or the person with whom they live to prevent loss of current housing. It's really more of a homelessness prevention activity. Legal services must be necessary to resolve a legal problem that prohibits the participant from obtaining permanent housing or will likely result in the loss of permanent housing. It's pretty narrow and it's got to be tied to housing barrier. Finally, credit repair. Credit counseling and other services necessary to assist program participants with credit skills related to household budgeting, managing money, accessing a free personal credit report, and resolving personal credit problems are all eligible, but it does not include the payment of or modification of debt. In other words, you can't use ESG to help someone modify their debt, and you can't use ESG to pay somebody's debt. Next slide, please. Housing stabilization services restrictions. They cannot exceed 24 months in a 3-year period, 36-month period. Case management must not exceed 30 days while seeking housing or 24 months while living in permanent housing. Participants must meet with a case manager at least once per month for the duration of assistance, unless funding under VAWA or FVSP prohibits the recipient, subrecipient, or subrecipient from making housing conditional upon services. Participants must be assisted to obtain supportive services as needed to maintain housing stability, and participants must be assisted to obtain mainstream benefits as needed, such as Medicaid, SSI, SSDI, and TANF. And generally speaking, most participants do need at least some of those mainstream benefits, and so their records should demonstrate an attempt to connect them with those benefits. Next slide, please. Giant red arrows, I love this. All units assisted with ESG Rapid are subject to the minimum habitability standards as outlined in the ESG program interim rule, no exceptions. Next slide, please. The recipient, subrecipient, or subrecipient cannot use ESG to help the program participant move into or remain in housing that does not meet, that's not true, move into housing that does not meet the minimum habitability standards. Sorry about that. They are listed below. I'm not going to go through them exhaustively. This will be distributed for reference for y'all. But generally speaking, this is the thing I would highlight here is many of you probably do have or know about continuum of care program funds that requires housing quality standards. Habitability standards is different from and is generally speaking a lower standard than HQS. They are distinct from each other. They are different kinds of inspections. Next slide, please. Please note, when ESG rental assistance or housing relocation and stabilization services are provided under RAPID to help a program participant move into new permanent housing, the habitability standards, everything got big all of a sudden. The new habitability standards apply to the unit into which they are moving and must be documented in the program participant's file. If rapid rehousing services are being provided before a unit has been identified, no habitability inspection is required until there is a unit to inspect. If assistance with arrears for a prior unit is needed as part of the rapid rehousing assistance, no habitability inspection is required for the old unit on which the arrears are owed, so long as the program participant will be housed using rapid rehousing funds in a different unit. Next slide, please. Back to you, Mike, for waivers and alternative requirements.
Yep, so as promised, we will discuss the waivers and alternative requirements. Everything that we just went through applies to annual ESG allocations. So these waivers and requirements we are going to talk about apply in a couple of ways. They apply to funding through the ESG-CV funding stream, and they apply to annual ESG funds from federal fiscal year 2020 and prior, when those funds are used to prepare for, and respond to COVID-19. So the first one we're going to talk about is expanded eligibility. So under those funding streams, there is a slightly expanded set of eligibility criteria for rapid rehousing. Specifically, if the person qualified as homeless immediately before they moved into their current housing, and they've been residing in housing with time-limited rental assistance provided under a homeless assistance program other than ESG. So we're thinking about continuum of care rapid rehousing, SSVF rapid rehousing if their time is running out with that. If they're using any other funding source that is time limited and it's running out. If they would not have any overlap in rental assistance between the non-ESG program and the ESG program due to exhaustion or expiration of the non-ESG assistance or program funds, and they would not have a gap of more than 1 month between the end of the non-ESG rental assistance and the beginning of their new ESG rental assistance, and they do not have the resources or support networks needed to retain their existing housing without ESG assistance. So that's a lot of stuff. It's basically saying if the person was homeless before they moved into their current housing and they are getting rental assistance from another source that's not ESG, and that source is about to run out and cannot subsidize them anymore, and they still need assistance. That is really what we're trying to get at here. So that is expanded eligibility for these funding streams. Some additional ones, project-based rental assistance. I'm not going to read this word for word, but it just changes some of the standards around project-based rental assistance. It's not a super common project model. So again, I'm not going to go through it in detail, but I would encourage you to reach out for support if you do project-based rental assistance and you need to understand that in more detail. Subleases. So subleases are not allowed under regular ESG. Program participants with these funding sources are allowed to rent a unit through a legally valid sublease with the primary leaseholder. Another really important one is match. So for ESG-CV and annual ESG funds for COVID-19 response, there is no match requirement. That is a big deal for a lot of agencies because the match requirement under standard ESG is 100%. More waivers. So the housing standards. Housing must meet minimum habitability standards, as we discussed previously, or housing quality standards before helping a participant move in or remain in a unit. Housing quality standards is a different inspection. It's used under the continuum of care program. I believe it's also used with HCV. And so it is a different inspection. It has actually a higher standard in most respects than the minimum habitability standards, but some agencies already perform HQS because of other funding sources that they have. So that is eligible to qualify a unit under these ESG funding streams. Fair market rent. The requirement that rent not exceed fair market rent is waived. So for ESG-CV and annual ESG for coronavirus response, fair market rent does not apply. You only have to meet the rent reasonableness standard for a unit to qualify. The definition of homelessness. An individual may qualify as homeless under Category 1 when exiting an institution where they resided for 120 days or less. That is different than the standard requirement, which is that they were in the institution for 90 days or less. So that is another important qualification factor under these waivers. And I'm going to turn it back to Gordon to discuss more waivers.
Love waivers. More waivers. Annual reevaluation income limit. At the required annual income evaluation for rapid rehousing, income must be below the very low income of 50% AMI limit instead of the usual 30% AMI limit. Time limits on rental assistance. Time limits on assistance. Rental assistance and services may exceed 24 months in a 3-year period, and case management may exceed 24 months while the participant is living in permanent housing. Housing stability case management. Case management may be provided for up to 60 days while seeking permanent housing rather than 30, which is the limitation under the interim rule, and participants are not required to meet with a case manager monthly, though services must still be made available to the participant. Next slide, please. Additional eligible activities. Volunteer incentives for necessary COVID-19 relief services. Hazard pay for direct COVID-19 relief services. Training to direct staff on infectious disease prevention and mitigation. Cell phones and internet for program participants while in the ESG program. And personal protective equipment or PPE for program participants. Please note the conditions and restrictions may apply to these additional eligible activities. Full details can be found in the relevant COVID-19 waivers and notices, the numbering of which is listed at the bottom of the slide. Next slide, please. Again, more additional eligible activities, landlord incentives to obtain housing for participants, sponsor-based rental assistance as an additional program model in addition to tenant-based and project-based, renter's insurance when it is required by the landlord, and furniture for use while the participant is in the rapid rehousing program. Next slide, please. In addition, childcare, education services, employment assistance and job training, outpatient health services, life skills training, mental health services, substance abuse treatment, and transportation. These are additional essential services for rapid rehousing. Next slide, please. Back over to you, Mike. Oh, puppies.
Oh, yeah. Yeah, I had to do dogs. I found twin dogs for this one. So duplication of benefits. We are going to talk a little bit about this very important thing, which HUD just recently released additional guidance on. So let's dive into that. So duplication of benefits occurs when a person, household, business, government, or other entity receives financial assistance from multiple sources for the same purpose, and the total assistance received for that purpose is more than the total need for assistance. So in essence, what we're saying is that resources were provided in excess of need. If resources were provided in excess of need, then a duplication of benefits has occurred. The applicability. So California HCD and its subrecipients must establish and follow policies and procedures to ensure that duplication of benefits does not occur at the activity and beneficiary levels. And we're going to talk a little more about what that means. Policies are applicable to CARES Act funding as well as formula funding used to prevent, prepare for, and respond to coronavirus. So in that previous slide, we talked about those two streams of applicability for the waivers. Same thing here. Policies must include a requirement that activities such as street outreach and emergency shelter are evaluated at an activity level basis, and rental assistance programs are evaluated at an activity and beneficiary level. So when we say activity level, that's for the most part at the recipient level. So that's what is being evaluated for emergency shelter and street outreach. And then when we think about beneficiary level, which is what is required for rapid rehousing, that means every assisted household. Policies must include a requirement that when short or medium-term rental assistance is provided, there must be mechanisms to recapture duplicated assistance paid to the landlord or property manager. I'm going to repeat that one too, because it's very important. If a duplication occurs, the policies and procedures must include a mechanism to recapture the excess assistance that was provided. Policies must include a method of assessing whether the use of these funds will duplicate financial assistance that is already received or is likely to be received. So this is what we're talking about when we say activity level versus participant level. HCD is required to evaluate duplication of benefits at the activity level. Since HCD passes ESG funding through to subrecipients, it may also pass the duplication of benefits analysis requirement through to them. So if you're a subrecipient of California HCD, then this can be passed along to you. Duplication of benefits analysis is required for all activities under ESG. Subrecipients and sub-subrecipients are also required to perform this analysis at the program participant level for each assisted household for homeless prevention and rapid rehousing programs. So as we're talking about rapid rehousing here, want to make that really important point. This assessment has to be done for every household. And I will turn it back to Gordon for a little more detail.
Thank you. So let's look at an analysis for duplication of benefits. So this is a way that you can assess whether you are looking at a duplication of benefits. So number one, you assess need. For each ESG funded cost type, determine the total amount of financial assistance needed. Number two, determine assistance. You determine the amount of funding that has or will be provided from all non-ESG funding sources to pay for the cost. Number three, you calculate the maximum level of the award by comparing the amount of assistance identified in step two to the total need, step one, to determine the maximum possible ESG award. And number four, you document your duplication of benefits analysis, documenting steps 1 through 3 and the ESG award amount to verify that the amount of the ESG award is equal to or lower than the maximum level of the award. Next slide, please. That takes us to intermission. Chris, would you like to step on in?
Yes, thank you, Gordon. So we had so many questions come up that we were actually going to pause intermission. We have about 18 minutes before we're going to go to intermission. We're going to try to answer as many questions that we got as is possible. So let's try to get through them. Either we'll get all questions or we'll stop right at noon Pacific and give you your break. Okay, so let me go through. We had so many questions. I got to find the beginning of them. Okay, I think, Mike, this talked to us something that you mentioned. So we have a community who has annual ESG in El Dorado County. They want to know if they can place a client from El Dorado County in a nearby county, and if so, which FMR would be required to use. Now, you were talking about it as far as how difficult it is to serve a client in another community, but we have a lot of smaller communities that are border that this might actually be useful. So it's a nuanced take on that question, I believe.
Yeah, so, the first thing I would say is just make sure that you are on the same page with the representative you work with at HCD, because it is state funding and they have to be in agreement with you. But in general, with state ESG funding, you could place a client in a neighboring county if that's what they choose and you have the capacity to serve them there. If you do that, the FMR that you use is the local FMR. So it has to be for the area where the unit is located. That's the short and sweet answer to that question.
Thanks, Mike. That was short and sweet enough. We have enough questions that short and sweet is good. Jennifer asked another question about providing written reference for the one-time rental assistance arrears only. We have done so. If other folks need that, please just let us know. We can give you the ask a question that answers that particular question. Okay, next question. This is a fun one because I know it comes up very, very often for us in California. Isn't rental arrears more homelessness prevention than rapid rehousing? And I kind of answered this, but I'd love a little bit more nuance. The answer is yes. The activities are pretty similar for homelessness prevention and rapid rehousing, but who you can serve is very different. Anyone want to jump on that one?
Yeah, I mean, I am happy to provide my perspective, and then Gordon can add anything that I miss. So I think the main point there is that, yeah, the eligible activities are pretty much the same between prevention and rapid rehousing. The main thing that makes them different is who you can serve. And depending on how your program design is set up, it certainly might be more common to make arrears payments under a prevention program, but they are also eligible under rapid rehousing. And, there can be instances where a person might owe arrears on a property that they were kicked out of 3 months ago or whatever, and they are currently experiencing homelessness, and they have those arrears on their credit, and they cannot get into a new unit until those arrears are paid off. So that's just one example of when you might see arrears payments under rapid rehousing. So it is something that you can do with rapid rehousing, and it is encouraged when that is what the client needs to get into a permanent housing situation. Did I miss anything there?
Not from the way we operate this program. Well, thank you, Mike.
Cool.
All right, 2 eligibility questions. I'm not sure who's going to want to take these. The first is, so if the participant has Section 8, meaning I took this to mean as they are being served by Section 8 and have a voucher, are they eligible for rapid rehousing under the ESG program?
Sure, I'll hop on that one. No, the short answer is no. You can't blend those two. There are duplication of benefits on one level and on another level, which I think we either briefly touched on or didn't touch on. Even if it were not a duplication of benefits and you could layer them over each other, the two programs are not compatible with each other. And so a short answer is no, you can't layer those onto the same household.
But I'm going to give you another situation here with another question, Gordon, that I think you're going to want to say yes to. What about rental assistance being provided for tax credit properties? Since the tax credit is a benefit to the developer, can rental assistance and deposit of rental assistance be provided to a participant in that particular property because it is tax credit? I know the answer because we just answered this, but I love the question, so I'm going to ask it.
I do too, and I love the answer. So we put some energy into this because we had this question and a different one come up. The answer is yes, absolutely. A duplication of benefits occurs, broadly speaking, when a participant benefits from 2 different sources providing the same benefit to the participant. But low-income housing tax credits are a benefit provided to the developer that does not accrue to the participant. And so absolutely you can use ESG rapid rehousing to subsidize a participant living in a unit that was developed using LIHTC or a similar subsidy.
Thank you. Okay, so here's a situation. Can we provide a rental deposit for a client when the landlord is not set a lease with us or contracted to provide us rental assistance? Mike?
So, yeah, so rental deposits, and correct me if I'm remembering incorrectly because I'm having brain fog at the moment, but are a financial assistance item. So that does not, in my experience, require an actual lease, correct?
The question was security deposits, is that right?
Yeah, that's financial assistance, and so should not require an actual lease, right?
That you're so I've got the interim rule up. You are correct as far as I can tell. You can provide a security deposit absent a lease, but in the event that rental assistance is provided at any point, and it would be unusual to provide security deposit without ongoing rental assistance, that then triggers the need for a lease as well as a need for fair market rent and rent reasonableness and all the other bells and whistles.
Great. Got to follow up to our LIHTC question because folks have additional questions about it. We've been told that we can only provide security deposits and rental arrears if a client is renting in tax-based property. If that is true in your community, I'm going to answer this myself, guys. Sorry. If that is true, that is something that either your community or your provider that you work for is determined. It is not a determination from the ESG or ESG-CV program levels. Okay, this one. Okay, so for ESG rental assistance, does shared housing qualify as a model that we can provide under rapid rehousing? Shared housing. And if we don't know the answer to that, I can punt that one because we have an answer to it another webinar.
I think in a general sense, the answer is yes, but I think there is a lot of nuance and detail that's beyond what we can get into right now because there are FMR, rent reasonableness considerations and things like that. So in a general sense, yes, but you really have to be careful about it and plan correctly.
That is also my understanding. And we're doing a session specifically on shared housing and how to do it. So we'll have a little bit more there, I believe.
If I can add just really briefly on the shared housing question, this is a great opportunity to think about what your written standards say. It's also an opportunity to think about, is this maybe a time for an AAQ and ask a question submission to HUD? Because shared housing is so complicated and because there are so many layers of written standards that proceed down from HCD and then up from HCD.
Yep. All right. Question about the 30 days. And I think, Mike, this was something you were talking about, 30 days of assistance prior to housing. So if we're helping find someone housing and 30 days have expired, we can no longer, those case management costs are no longer eligible on day 31. Is that correct?
So yeah, case management, it depends on which ESG funding stream we're talking about. So if it's regular annual ESG, then it's no more than 30 days prior to housing. If it is ESG-CV or annual ESG, fiscal year or federal fiscal year 2020 or prior, being used for COVID response, if it's either of those things, then it's 60 days prior. And that is a hard limit. It's regulatory. However, housing search and placement services can be provided farther out. So if you're serving someone that, you know, has likely, say 3 months before you think you can identify housing for them, housing search and placement is most likely what you would be providing them in that situation. And then you start to phase in the case management when you get closer to housing move-in.
Okay, I'm going to do a twofer that came in kind of questions similar. Can we assist those living in hotels, motels under under rapid rehousing? And is there a limit on how many days you can be in hotel, motel and receive assistance from rapid rehousing, which is kind of tied to what you just said, Mike?
I'll jump on that one. It depends on who's paying for the hotel motel. So if the hotel motel is being paid for by a charitable organization, a nonprofit organization, or a governmental entity, in other words, if the participant is not paying for it themselves or their support networks are not, then yes, you can serve a person who is living in a hotel motel. It qualifies them under the literal homelessness definition. That includes, incidentally, hotels, motels paid for under the emergency shelter component of rapid rehousing. That is a qualifying location to enter rapid rehousing from. If the participant is paying for their hotel motel stay themselves, or their support network is paying for them, or it's not one of those entities I just discussed paying for it, then it is not a qualifying location for literal homelessness and does not qualify for rapid rehousing, though it would be qualifying for homelessness prevention.
Thank you, Gordon.
Oh, and I'm sorry, I missed the second part of the question. There is no limitation. There is no limitation on the duration of stay in a hotel motel. Though under most circumstances, the functional limitation is how long the organization is willing to pay for the stay.
Right. Okay. We have about 7 questions left. We may not get to them all, but we do have another Q&A session after intermission. So we're going to do our best. You guys have got some great questions today. This one's on duplication of benefits. It only matters that services not be doubled, even if the funding received is different. For example, someone receiving HP from another agency also enrolled with rapid rehousing for a different agency. So I think duplication of benefits was you, Mike, but whoever wants to take that, please go forth.
Yeah, I can jump on that one. And again, HUD's guidance on this is still relatively new. My understanding of it, though, is that, yes, we're talking about duplication of benefits for the activity regardless of funding source. So not providing ESG funding that constitutes an excess of benefits. So I think what was proposed there in the question is correct. If the household is receiving the same type of assistance from another source, then ESG cannot create a duplication, even though the other assistance is from another source.
We've had a few questions we've answered in the chat, so I'm going to leave those be and kind of go to the ones we haven't. We keep talking about waivers. What is that? Is that a form? Where do we go to find those? What are waivers?
So I'll hop on that one. So what we're talking about are the ESG-CV, or the ESG COVID-19 response notices and waivers that are published by HUD that detail additional flexibilities or modifications to the ESG program interim rule, as well as additional eligible activities. The names of those waivers were listed on the relevant slides earlier in this presentation, and I can dig up a link to them on the HUD Exchange and drop it in the chat for y'all.
Also at the end in the resources section, I believe we have a link to those too.
Maria Martinez asked a question about a specific program called Rapid Way Home Vouchers and can they be used with ESG? Maria, we can't answer that question because we don't know that program. So I will make sure that my email's in the chat. Go ahead and send that to us in writing, and we'll try to track that answer down. That's one that's kind of a little bit out of our depth at the moment. Are moving costs such as a moving van eligible under rapid rehousing or just relocation?
So moving costs are eligible under rapid rehousing. And I'm not exactly sure what we're referencing with the relocation piece.
I'm not either. These are coming out of order and out of where we're talking about them. So just talk about the moving costs. I think that should do.
Yeah, I mean, so moving costs are an eligible expense under rapid rehousing. So it is something you can spend ESG money on. I would encourage you to reference the ESG program interim rule for specifics. There is a little more language around what's eligible. I believe your moving van would be, if I'm not mistaken. So yeah, I would reference the program interim rule, but moving costs are eligible. Yeah.
Okay, so just a clarification, this is again, we're going back to Section 8. In the past, persons living in Section 8, we've been able to pay deposit that is not covered by the voucher. Anyone have any guidance there? Or is that definitely go to the AAQ?
I would say go to the AAQ.
Eva, we're going to send you to the ask a question on that particular one. Did I get all the questions, Kristen? I feel like I might have not gotten them all yet. Ooh. Oh. There's a question about the shared housing session that I talked about. It is scheduled, but it's not for a while. We do have a shared housing session that we did on our landlord that Monica, I'll try to find the link and post it in the chat during intermission. I have a question here. We have a participant who have a housing choice voucher, so the rent is covered. They need assistance with paying utilities. Can we provide utility assistance using ESG for participants with a housing choice voucher? I think, again, that's one we're going to want to put to the AAQ, 100%. So that question asker, please go to the AAQ.
Chris, I stuck one question in our group chat, but I think other than that, you've caught them all.
Yeah, I did. That's the one I just
Gotcha.
Just asked.
Then I think we're caught up.
I think we are as well. Jacqueline asked, how would we go about renting a moving van for a client under rapid rehousing? I actually don't know the logistics of such. So, and yes, we can put a link to the AAQ. Okay, I think I hit them all. If I didn't, please send me a direct message and we'll get you afterwards. Okay, so now we are actually at intermission. You had just so many great questions. I did not want to let any of them marinate any longer. Mike, can you remind us what we're doing after intermission before I believe we're doing best practices and then we're going to go into lightning round. Is that correct?
That is correct.
Excellent. So come back in 5 minutes. So we'll call that 12:05. We're going to pause the recording now, and then yes, I'll put a few things in the chat while we're doing our intermission. But come back right at 12:05 Pacific, and we'll get to it. Thank you. Welcome back from intermission. We are getting ready to head into our second half of the presentation this afternoon. I'm going to hand it back to Gordon Levine to get us going.
All right. Back back from the intermission, let's go. Let's talk about rapid rehousing best practices. And that's a team of scholars practicing. Next slide, please. Housing first. So rapid rehousing is a housing first intervention that prioritizes providing permanent housing. And again, remember, rapid rehousing is a kind of permanent housing to people experiencing homelessness, thus ending their homelessness and serving as a platform from which they can pursue personal goals and improve their quality of life, as well as achieving stability in permanent housing. Elements of Housing First include rapid placement into permanent housing with minimal barriers to access and entry, wraparound services to help achieve stabilization, monthly case management at minimum, more frequently may be needed, no requirements for medical treatment or mental health treatment, no sobriety requirements, no requirements that a person have a certain level of income, no program participants following terms of standard residential lease agreements, that's still a requirement, and program participant choice increases the likelihood of long-term success. Ultimately, empowering participants to access projects quickly and with minimal barriers and with maximum self-direction improves the odds of achieving and sustaining permanent housing. Next slide, please. Core components of rapid rehousing. There are three core components to a successful rapid project. While all projects must make all three available, projects are not required. It is not required that a single entity provide all three services or that a household utilize them all. Meaning that while all of them must be afforded to each household, subrecipients can contract with outside entities to provide some or all of those services, and households are not required to take advantage of all of them. They must simply have access to them. One of them is housing identification, so housing search, basically housing search, finding housing. One of them is rent and move-in assistance, and one of them is case management. Next slide, please. So housing identification includes building relationships with landlords. Best practices around that include recruiting landlords continuously as an organization. You shouldn't wait until you have a housing need to be out looking for landlords. Establishing a pattern of relationships with landlords will help you tremendously when it comes time to house someone. First and second, creating access to as many units as possible. This goes back to participant choice. At the end of the day, participants who are empowered to choose where they live will ultimately be more successful over time. It includes finding and securing housing as quickly as possible. Fast access to housing after the household begins experiencing homelessness is critically important because it reduces the negative impacts of homelessness while increasing the odds that folks will retain stability once they get into permanent housing. It also involves matching participants to appropriate housing, again, based on client choice. If people choose where they want to live, they're more likely to stay housed there. Finally, limiting the time a household spends experiencing homelessness is critical. Moving people into housing in 30 days or less is the ideal, and minimizing the time spent in shelters and on the street are, for obvious reasons, good things when you want to ensure that people reintegrate into housing after an episode of homelessness. Next slide, please. More on housing identification. As I said, recruiting landlords even before people who need housing have been identified. It both builds relationships with landlords and it cuts down on the housing search time. Creating formal partnerships with landlords helps to solidify that relationship. Employing specialized housing identification staff is critical. Finding landlords and building relationships with them is a skill and requires an investment of time. Therefore, it ought to be identified as a job duty, even if it's not the only job duty. Offering flexible landlord incentives based on local market standards, either through ESG-CV, which does offer landlord incentives as an eligible cost, or through other available flex funds can be a powerful tool for building and maintaining landlord relationships. And finally, ensuring that housing is decent, safe, and affordable for participants after assistance ends is critical. Participants will not remain stably housed if they are not living in housing that meets their needs. Ensuring that it will, even after the assistance ends, is how you ensure that your outcomes, even 2 years out, are still looking good. Next slide, please. Over to you, Mike.
All right, so we're on to the next component, rent and move-in assistance, often the area where the rubber hits the road in terms of financial assistance. So, first thing here, pay for security deposits and move-in expenses, and then pay for rent and or utilities. So make those payments and get participants into that permanent housing. And then tailor the length of assistance to the household. That's a really important one. And we're going to talk more about that on the next slide. So when we think about tailoring the length of assistance to the household, What we are really talking about here is progressive engagement, which is considered to be a best practice in how households are served through rapid rehousing. So the progressive engagement model requires an incremental and tailored approach to identifying and meeting the needs of participants throughout project engagement. This approach both supports household independence and ensures that resources are deployed efficiently. So, again, we're giving the household some power over their own situation and making sure that resources are distributed efficiently to the households that need them the most. So under progressive engagement, you initially provide a basic amount of financial assistance and case management that's just enough to help the household obtain and sustain housing. So you're providing them the services and the money that they need to get into that unit and start to become sustainable there. And then, using a person-centered approach, periodically assess if the household requires more assistance to maintain stability. So there's an ongoing assessment of what that household needs. And then, based on those ongoing assessments, extend financial assistance and case management only as necessary to maintain stability if the initial amount was not enough. The case manager's relationship with the household is really critical in this process because they need to know that household, understand their needs, and understand if they're getting what they need or if they're going to need more, because it is okay to provide them more. We're not saying, cut households short under this model. We're just saying always know what they need and provide them just what they need so that other households that also need assistance will have that available too. So it's, again, efficiency of distribution. If the assistance is reaching the maximum amount, so that could be the regulatory maximum or the maximum under written standards. But if the maximum amount of assistance that can be provided is coming up and the household still does not appear able to maintain stability, the case manager, first of all, needs to see this coming. So those ongoing assessments, they should really have an idea if this is going to be the case. And if so, they should consider seeking long-term subsidies, which might include housing choice vouchers, permanent supportive housing if there's a disability involved. And there's other stuff out there too, emergency housing vouchers, for instance. So seeking a long-term housing subsidy, because that is going to be the best solution for a lot of households. So some notes for rent and move-in assistance. The goal is to help with the costs associated with getting into housing. The amount and duration varies, but at a minimum, it should be enough to help people secure a place to live. So of course, at a minimum, you want to get them into that permanent housing. The assistance shouldn't be a standard package, but it should be flexible in order to meet the unique needs of the household, as we just talked about with progressive engagement. I know in years past with programs I've worked with, it was not uncommon to see programs that had policies saying, for instance, we will provide 3 months of rental assistance and that's it. And that's what every household got. That's not appropriate. It shouldn't be a standard package. It should be tailored. This is particularly important when financial circumstances or housing costs change. That's, again, getting back to that ongoing assessment piece. Household situations will change and the assistance provided should change along with that. So key considerations for rent and move-in assistance. You want to avoid the cliff effect by using step-down assistance. So as the household is gaining more ability to maintain their own stability, you can start to taper off the assistance. So you kind of wind it down over time, and that avoids the effect of having a cutoff where, say, the household is receiving a 100% rental subsidy, and then all of a sudden next month there's no rental subsidy. That's the cliff effect. And you can avoid that by, again, progressive engagement, ongoing assessments, and tapering off services as it's possible. Leverage other local resources for other household needs. There are many things a household will need that will probably not be covered by ESG, but there will be other resources available. So knowing those resources and connecting households effectively. Establish clear workflows for processing financial assistance payments. That's a very technical thing, but it's very important. It's hard to build landlord relationships in a lot of places, and you don't want to burn those relationships by making late payments all the time. So having clear workflows and making those payments on time. Plan for unpredictable but urgent costs. There will always be unexpected things. So, having a flexible pool of funding or a wide array of resources outside of ESG, those are ways that you can kind of plan for that and mitigate the effects. And then track and frequently update current and projected spending. Again, another technical thing, but it's very important, especially when we're talking about flexible assistance and, providing households what they need in the moment. That's going to cause some variation in spending from month to month. So tracking that and knowing what your budget looks like is very important. And back to you, Gordon.
Thank you. So let's talk about case management. There are lots of different angles that case management can use to approach a household's needs. Everything from childcare, healthcare, employment, to income, benefits, and education. But all of them ultimately must be tied back to the household needs. In other words, they need to be tied back to ensuring the household is able to overcome their housing barriers and achieve and maintain stability in permanent housing. Next slide, please. The goal of rapid rehousing case management, as I said, is to help stabilize people once they're housed by connecting them to services and supports as needed. Case management should focus on helping people navigate the barriers that might stand in their way of securing and maintaining housing, and should also strive to build a support system by connecting them with the people and programs in the community that can help them achieve that stability. It involves both connecting families and individual people to services and supports in the community, and helping to resolve the issues that might threaten their stability, including conflicts with their landlords and potentially other folks. Next slide, please. Case management can include, for example, critical time intervention for rapid rehousing, or CTI-RRH, which is a time-limited, evidence-based practices that mobilizes support for vulnerable people during periods of transition. CTI and rapid are complementary interventions, with CTI offering a structure for practice that focuses on service interventions, while rapid focuses obviously on housing interventions. Next slide, please. Critical time intervention highlights. CTI is time limited. Its explicit aim is to provide intensive targeted support during a critical period and then to withdraw. It's compatible with efforts to intervene with people in crisis, especially during periods of housing instability. CTI is not intended to become a primary source of ongoing support for vulnerable people. CTI workers aim to engage clients, locate effective supports and services in the community, and effectively link them together to promote long-term stability within the household after they withdraw. Finally, CTI is highly focused. CTI workers do not try to address all the needs that individual vulnerable people and families might have. Rather, CTI focuses only on the key areas that place clients at risk of future housing instability. Next slide, please. Key considerations. Focusing on resolving the current crisis. Rapid rehousing is not an anti-poverty program. It is a housing program for people experiencing homelessness. Focusing on trauma-informed and strength-based approaches in case management. Supporting participant choice, both in terms of service engagement and in terms of housing choice. Providing individualized, flexible, and household-specific services. So that involves both identifying what those needs are and tailoring your service offerings to each individual participant household. And finally, closing the case. Participants need plans for future housing crises, even after you move them out of a rapid rehousing project. Next slide. Back to you, Mike, to introduce the lightning round.
All right. So we went through a lot of material and we made it through faster than I thought we would. Maybe we'll take that as license to make even longer PowerPoints in the future. So we are going to start the lightning round. So again, we've been through a lot of stuff. Now we're going to ask some questions about the material. We're going to see what we learn. And hopefully that will spur some questions if you have those, because I think we are going to have some time to address those at the end as well. So let's jump right into the lightning round. Question number 1. Which of the following is not an eligible activity under ESG rapid rehousing? Housing stabilization, engagement, short-term rental assistance, medium-term rental assistance. You should see a poll pop up on your screen. There you go. And you will be able to choose your answer, which one you think is correct. I'm just kind of watching to see the answers coming in. Looks like we've got about 45% of people participating so far. Looks like we've got a few people still answering, and we've got a few answers across the board on this one. Okay, looks like we might be slowing down. Yeah, I think we can go ahead and close this one out. The overwhelming majority here has chosen engagement. So let's take a look at the correct answer. That is absolutely correct. Engagement is not an eligible activity under ESG Rapid Rehousing. It is eligible under the street outreach component. So stay tuned for a presentation on that at a later date, but not eligible under Rapid Rehousing. So good job, everyone. Got that one. Nailed it.
All right, question number 2. Which of the following is true regarding fair market rent and rent reasonableness assessments for ESG rental assistance? Which of the following is true? Local standards for determining rent reasonableness are defined by the recipient and/or subrecipient policy. Fair market rent and rent reasonableness requirements apply consistently across all ESG and ESG-CV funding. Fair market rent and rent reasonableness apply equally to all rapid rehousing rental assistance payments, even if the payment is solely for rental arrears. And the contract rent amount for a unit must be compared to the local fair market rent and rent reasonableness to assess for compliance. Which of the following is true? Poll should be up in front of you. Go ahead and plug in your answers now. Excited to see the answers. Oh, the answers are pouring in. Storming in even. There's a lightning round joke. Okay, looking good. We'll give about another 10 seconds for that. Answers still coming in. Want to give people time for that? Such an active group today. We really appreciate all of you and the engagement that you're giving us. It means a lot to us as folks who are excited about and engaged with your community. All right, I think we're good. Overwhelmingly, 3/4 of y'all thought the answer was the 4th answer up there. The contract rent amount for the unit must be compared to the local FMR and rent reasonableness to assess for compliance. Let's have a look at the answer. While HUD provides basic guidelines, specific local standards for rent reasonableness are determined by the ESG recipient and/or subrecipient policies. So the correct answer is the first one on the screen. Fair market rent is only applicable to HCD ESG funding for FY 2021 and forward. Rental arrears only payments are not subject to FMR and rent reasonableness. And finally, FMR and RR comparisons are done using gross rent, not the contract rent amount. Good question, good thinking, and a little bit tricky. Next question, over to you, Mike.
Yeah, and that one was a little tricky, and that was on purpose because it is a tricky concept. But when you're doing those comparisons, it has to be gross rent. And that is one that I have seen many agencies get tripped up on before. It's easy to do. Question 3. When calculating gross rent, which of the following should not be included? The contract rent amount, occupancy fees required by the lease, pet fees required by the lease if the participant owns a pet, and utility allowance. Which of those would not be included in the gross rent calculation? Yeah, once again, the answer is pouring in. Got a few answers across the board, but looks like we definitely have a solid majority on one of those. Also should mention that we cannot tell who is putting in which answer, so it is completely anonymous. So feel free to guess away if you have no idea. We will have no idea who you are. All right, we're over 50%, so we can close that out. The overwhelming majority here said pet fees should not be included. Let's take a look. That is absolutely correct. Pet fees are not included in calculation of gross rent. It is comprised of the contract rent, occupancy fees required by the lease that are reasonable and consistent across all the property owners' leases, and a utility allowance based on the local PHA's utility cost schedule. Back to you for the next one, Gordon.
All right, true or false? A rental assistance agreement is required when a payment is made solely for rental arrears. True or false? Rental assistance agreement is required when a payment is made solely for rental arrears. This is a great question. I think this is the 6th time we have touched this in 2 hours.
Yeah, rental arrears are a weird one because there are certain things that are not required that would normally be required of rental assistance payments, and there are other things that are still required.
Yep.
It's tough to keep track of them. That's why we put this question in here.
Absolutely. And it's a good answer to have too. And it's helpful in a lot of ways because it helps you think through the way the ESG interim rule works in a lot of ways. So answers are kind of slowing down. Looks like we're capping out. It's interesting. We, a solid half of you said false and a third of you said it was true. So it's pretty even. Let's go ahead and see the answer. It is, of course, true. When a payment is made solely for arrears, a rental assistance agreement is still required, and it should detail the amount paid by the recipient and subrecipient, include the number of months of arrears paid, and any other terms and conditions of payment. However, we will note, as we said earlier, that there are things that are not required when payments are made solely for rental arrears, like, for example, an FMR and RR calculation, though that is required if rental assistance kicks in later. Back over to you, Mike.
All right. Next question. Which of the following is not true under the waivers and additional flexibilities for COVID-19 response? So we had that whole section on waivers and flexibilities. Which of these is not true? Time limits are waived to allow for more than 24 months of assistance. Oral lease agreements are acceptable to establish amounts for monthly rental assistance payments. Essential services eligible under the emergency shelter component are also made available to rapid rehousing participants. Fair market rent requirements are waived. One of those is not true. Tell us which of those you think it is.
Oh, this one's tricky too.
It is. There's a strong showing for one particular answer too. Yeah, very active group today. Thanks, everyone. Yeah, we're probably getting pretty close on that one. Can we get 60% of people? Maybe, not quite. Almost. Over 60, I'm happy with that. All right. The oral lease agreement is the one that got the most votes. So let's take a look at the correct answer. That is the correct answer. An oral lease agreement is only acceptable when payments are solely for rental arrears and only to the extent that it gives a program participant an enforceable leasehold interest under state law. The agreement and rent owed must be sufficiently documented by the owner's financial records, rent ledgers, or canceled checks. This is the same standard applicable to all ESG, and it has not been changed by any of the waivers and flexibilities. So important to note, this is not any kind of exception. This is always what is true under ESG.
All right, questions. I'm getting the true and false ones here. I think the deck is loaded. Question 6: true or false? Participant eligibility requirements for ESG Rapid were not changed by the waivers and additional flexibilities. Is it true or false? Participant eligibility requirements for ESG Rapid were not changed by the waivers and additional flexibilities. This is a tricky one too. I think sometimes we look at true and false and we're like, yeah, this is going to be the easy one. But no, the multiple choice ones, sometimes those can be the easy ones, and the true and false ones are the tricky and sticky ones. There's a reason not sure is up there as an answer.
Yeah. On multiple choice, you can do process of elimination. True and false is not quite as straightforward.
Yeah. So that looks like pretty much the full group. 2/3 of y'all thought it was false. Let's have a look at the answer. It is, of course, false. Participant eligibility was changed to allow those exiting an institution after 120 days or less to potentially qualify for assistance, which is raised from the normal 90-day limit. Eligibility criteria was also changed to allow those receiving time-limited assistance from another homeless assistance program to potentially qualify for assistance under ESG Rapid. Back over to you, Mike.
Okay. Which of the following is not true regarding the duplication of benefits or DOB analysis? Duplication occurs when resources were provided in excess of need. Duplication must be assessed at the activity level and at the participant level for rapid rehousing. If duplication occurs, excess benefits must be paid back. California HCD is solely responsible for assessing duplication of benefits across its ESG rapid rehousing funding portfolio. Which of those do you think is not true? No, this must be a tricky one. A little slower this time, and that's okay.
Oh, that's really interesting.
I think we might have some HCD employees answering. Just kidding, guys.
Well, this is tricky. There is a way in which this is tricky. I can kind of see that.
It is tricky.
No, yeah, I can see that. If I put on my used to work at a community action agency hat, I can be like, yeah, I can see how I don't believe that.
Yeah. All right. I think we're pretty close on that one. We have a consensus on the HCD as solely responsible answer. So let's see. That is correct. HCD is not solely responsible for performing the duplication of benefits analysis. It bears the ultimate responsibility because it is the ESG recipient, but may choose to pass along activity level duplication of benefits analysis to subrecipients. Also notable, subrecipients and sub-subrecipients are responsible for performing participant level duplication of benefits analysis for all ESG rapid rehousing assisted households. So there is responsibility across the board. It is not just HCD's responsibility.
Okay, question 8. Which of the following is not true of the Housing First model? Which is not true? That Housing First prioritizes rapid placement into housing with minimal barriers. That participants in Housing First programs must still follow all standard lease requirements. That Housing First may include reasonable treatment, sobriety, or income requirements. Or Housing First includes comprehensive wraparound services based on household needs. Which of these is not true? Excellent work, by the way, behind the scenes on the poll timing. They're going up at exactly the right time. Just wonderful. Big shout out to everybody working on this presentation. Okay, well, a lot of people feel really strongly and really directly about Housing First, which is great. Okay, give it a few more seconds to see some answers keep rolling in.
Look at that consensus.
Yeah. All right, well, let's call it good. I think that's disproportionate. 4 out of 5 of you think Housing First may include reasonable treatment. It may not include reasonable treatment, sobriety, or income requirements. Let's see what the answer is. Housing First prioritizes rapid housing placement with minimal barriers, which includes no treatment, sobriety, or income requirements. So all of y'all thought that were correct. Elements of Housing First also include wraparound services, monthly case management consistent with ESG requirements, and a strong focus on participant choice. Back over to you, Mike.
Thank you. Number 9, which of the following is not an element of progressive engagement? So provide initial services that are just enough to secure housing, establish a minimum amount of assistance to which each household is entitled, periodically assess household needs and extend assistance only as necessary. When maximum assistance is reached, seek longer-term subsidies for the household. One of these is not an element of progressive engagement. Which one is it? Oh yeah, we have some distribution between the answers here. And they are still coming in. I'm going to say it again. I appreciate the participation. It's really nice when we have an active group on these.
Yeah, and a willingness to say, this is what I think, and let's find out what the answer is. It really, it means a lot to see folks engaging with the content.
Yep. All right, looks like we slowed down a little there. So I'm going to talk about this distribution for a second. You know, we have option 1 there, provide initial services that are just enough to secure housing, got 43%, which is the most. But close behind, establish a minimum amount of assistance to which each household is entitled, also got 30%. And the last option, when maximum assistance is reached, seek longer term subsidies, got 20%. So it's a decent distribution there, but let's look at which of those is not an element of progressive engagement. The correct answer is the minimum amount of assistance to which each household is entitled. That is not an element. Progressive engagement does not prescribe any minimum amounts of assistance for households across the program. Rather, it focuses on ongoing active assessment of each household to determine the necessary amount of assistance to obtain housing and maintain housing stability. If a program defined a specific amount that every household was going to get, or a specific maximum, that's when we talk about those cookie cutter programs that I was mentioning earlier, where it's a defined package for every household. That is kind of the opposite of what progressive engagement would prescribe. Back to you for question 10, Gordon.
All right. Which of the following is not an element of critical time intervention? And remember, critical time intervention is a case management technique that is complementary in rapid rehousing. Which of the following is not an element of CTI? Is it that CTI is rarely a good fit for rapid rehousing case management, that CTI is time limited, that CTI is highly focused, or that CTI only addresses key elements of risk for housing instability? Which of those is not an element of critical time intervention? Wow, interesting. This is a tricky question. So Mr. Michael Thomas is our question master for the day. And is setting fiendishly difficult questions, which I'm enjoying very much.
I like my tricky questions. I have done worse questions before, though.
No, that's true. That's true. Well, I think both of us have done more challenging questions to smaller groups of people, admittedly. All right, we got 31 responses. Can we get just a few more? And we got more people in the audience. Anybody else have an opinion on CTI? Thank you to the 2 of you who just clicked in. All right, let's call it good. So half of y'all said CTI is rarely a good fit for rapid case management, and a third of you said CTI only addresses key elements of risk for housing instability. Let's see what the answer is. CTI is a complementary case management strategy for rapid rehousing. CTI is centered around time-limited, focused provision of services and resources to address immediate barriers to housing stability. Along with Housing First and progressive engagement strategies, CTI helps ensure that resources are allocated efficiently while still providing effective assistance. In other words, it is not rapid case management, or it's not a good fit for, it's rarely a good fit for rapid case management. It is a complement to rapid case management. So good job to y'all who got that right. Tricky question. Back over to you, Mike.
All right, that wraps us up with the lightning round. So I'm just going to point out some resources here. We have a pretty dense resource slide today because there are a lot of resources that can be useful for you. So of course, there's the ESG program interim rule, the HUD ESG virtual binders. That's another online resource from HUD that can get you, compliance information and information on regs and things like that. So we'd encourage using that. Fair market rent and rent reasonableness guide specifically for ESG. I would highly recommend that you take a look at that. The minimum habitability standards, again, very useful information from HUD on that. The ESG-CV waivers and flexibility summary, the specific link we put here is for a resource that shows side by side ESG-CV and annual ESG. And for every waiver, it shows you when it's applicable. That's a really useful tool if you have ESG funding right now, especially ESG-CV. Duplication of benefits guidance, again, like I said earlier, that's a pretty new resource from HUD. Would certainly recommend checking that out. And finally, the National Alliance to End Homelessness Rapid Rehousing Toolkit. I put that on here because the reality is most of that best practices content I took from the National Alliance. So I put that there so that you can check into that. If you want to learn more about best practices, if you liked what we presented, I would certainly suggest it because they have an entire guide. It has a lot more detail than we went through, and it's a useful resource. With that, questions?
Thanks, Mike. Thanks, Gordon. Thank all of you for staying with us. We know that folks get a kick out of the lightning rounds. So we put them together so you can have a little fun after an hour and a half of content. It's nice to have a little bit of break. We do have time for Q&A. As I said, we did try to get all the questions before intermission. I skipped a few. You all pointed that out. So thank you. We will get back to those. I want to get to just a general question that always arises. So yes, the recording that is currently going on and will be completed shortly will be sent along with the presentation materials today for you to have. We will also be posting that on our website and ultimately on the California HCD training website as well, though that takes a lot longer. So all these resources will be out for you shortly enough. Okay, so I did miss a question from Caitlin, though I think we answered pieces of it. There were so many to combine that I think I missed one from Caitlin. For ESG-CV rapid rehousing, is renting a room in a house eligible?
Which one? Doesn't matter to me.
I'll go for it. I'll go for it. I want to refer earlier first to the shared housing question. Shared housing is tricky and there are lots of nuances. Renting a room in a house is part of the shared housing question. And so I don't want to provide too much of a specific answer because there are always going to be nuances. But generally speaking, there is, with absent any other detail, right? Absent any other detail, there is not necessarily anything wrong with renting a room as long as the room and the facilities to which you have access meet minimum habitability standards. And there is a process for assessing a room in a house under fair market rent, and there are nuances around that. And I would recommend reviewing the FMR and RR guidelines around that to kind of get deeper into that. But the short answer is, on the surface, absent other details, it's allowable and often a good idea in rental markets where that's kind of what you have available, but there are nuances to it.
Good answer, Gordon. Thank you. And I may have asked that before, and if I did, I apologize. Just trying to catch all of these. So Kelly asked a question as well for non-competitive ESG-RR contracts. So Kelly, first I'm going to say, if you really need more nuance on your annual ESG, I encourage you to reach out to your California HCD ESG rep to get specific guidance. So I'm going to leave that part of the question out and going to just ask the second part. So under rapid rehousing, are we allowed to help with rental arrears? Part one. Part two, do we need to enroll those folks in the program, or is that one-time assistance? And are we required to enter an HMIS? I guess that's three questions for which I believe we all know the answer, but who would like to take a crack at that?
I'll jump on that one. So the answers are yes, yes, and yes. You can help with rental arrears. If the person is being assisted with ESG, then yes, they must be enrolled in your ESG rapid rehousing program, and that must be entered in HMIS.
Yes, yes, and yes. That's exactly what I was looking for, was three yeses. So yes, you can do rental arrears. Yes, you'd enroll them in the program, even though it's only one-time assistance. And yes, always in HMIS. If you are doing case management, if you are doing cutting a check for rental arrears, definitely want those to show up in your homeless management information system, HMIS, so that we can report those things properly to HUD and to California HCD. I have no other questions, so I will go ahead and open the floor. Would you like to come off mute and ask a question? You are welcome. You can raise your hand or just come off mute. or we will give you back a bit of your afternoon.
I think I see a hand there.
I do. Hey, Teddy.
Hey there, just a quick question to follow on Kalia. Some of the HMI systems come with forms that are called COC minimum forms that don't contain all of the income, the health questions, the night before, where they went, all that kind of thing. Are you seeing that? I'm just curious if any of you are seeing that kind of COC minimum enrollment form in any other systems, and if to Kalia's question, because that's a lot of work for one arrears payment. Is, you know, a rent is, and we encountered this with utility payments as well, where you put a whole enrollment in and the next day you'd have to exit them, and they exited all to housing. So it kind of, you know, made the outcomes look really good, and it was a lot of work for the provider. Not a lot of value, but a lot of work.
Yeah, I mean, I think I got a few reactions to that. One is, and I'll go ahead and lower Teddy's hand. HMIS and the workflows within each HMIS solution itself are very different. What we are really saying around ESG and ESG-CV is collect only what you need to collect. So unfortunately, that is the requirement this falls under. If you're serving someone and you're passing money, rapid rehousing to folks, you would want to collect all the information. I would also kind of point out that when we look at rapid rehousing, doing rental arrears, it's allowable, but we have a tendency to blur the line between homelessness prevention and rapid rehousing because they look the same as far as what they're eligible for. However, it's about who is coming for assistance. Are they literally homeless? Are they at imminent risk of homelessness? That's going to tell us a very different thing. We want those programs that are for literally homeless to really be more on rapid rehousing, and rental arrears rarely is enough to truly stabilize someone in a rapid rehousing program.
So just to follow on to that, rental arrears, if that were to happen to be the case under rapid rehousing, we could do a client profile and a service record and not do the enrollment. Yes, no? Still auditable? Okay.
You would have to collect all the universal data elements as required by any ESG interaction.
All right,
So,
cool.
Thanks, Teddy. All right, we have a question from Jennifer. Is there a limit to the amount of rental arrears?
I'll hop on that one. There are two limits on rental arrears. One of them is rental arrears is limited to at most 6 months of rental arrears. And there is a cash amount limit, which is you can't pay more for a given month of rental arrears than was charged for rent in that month. And so, for example, if the lease is for $1,000 a month, you can pay up to $6,000 of rental arrears for that client. But you can't say $10,000 because that's what they've accumulated and just say, oh, well, that's 6 months worth. And so really what it's saying is you need to look at what the lease amount was for, and you can pay up to 6 months historically of that lease amount. And so it is participant specific rather than a statutory cash limit.
Thank you, Gordon. Jennifer, I see your question. I do not know. Would you like to ask verbally? Maybe we can try to get to the answer. This may also be something you just want to follow up individually. It's up to you.
Yeah, I recently had a client that because we could not use CV funds for a minute because we had to update our policies and procedures or CV1 funds. So relocation, she started off a relocation. She was housed, needed to leave because her rent got to be out of control and she was being evicted. So, my understanding is relocation under CV1 and homeless prevention is different than, CV2 rapid rehousing, right? So she actually became homeless in the time that we weren't able to use CV1. So we switched her to rapid rehousing. So that got even more confusing. But so, CV1 prevention has a whole list of things you can do. That why I asked the moving truck question, because under the guidelines, I noticed moving truck under relocation, but not rapid rehousing. So it gets kind of confusing bouncing between the two. So yeah, so my second part of the question was, if we're relocating, can we pay those rental arrears while, if they're still housed and being evicted, and then rehouse them? you know, I know you can only pay deposit and first and last with relocation, right? So does
So
that go for the same 6 months? We can pay the arrears on relocations and then just the deposit and first and last on the new house?
So I think, Jennifer, we've got a few things kind of that I need to untangle for my own mind to wrap around this. When you talk about ESG-CV1, so there were 2 tranches of ESG-CV that came out. They, from the federal standpoint, are identical, doesn't matter. For the state of California, under one and not the other, we had the ability to do homelessness prevention. So you could do homelessness prevention under ESG-CV1, but we didn't make it an eligible activity under 2, even though that's the same program technically. So I think that's part of one of the things that I need to untangle here. I also think that most of your questions are about what can you do, not do under homelessness prevention, which is not necessarily the topic of today. So I don't want to get too deep in it because we're going to do a session on homelessness prevention, I think in 2 months, where we can get a little bit more prepared for that. We were prepared more for rapid rehousing questions. So when I untangle all that, what are your rapid rehousing specific questions that maybe we can answer?
Yeah, I just kind of tangled CV1 in there. Sorry about that.
It's okay. I had to pull it apart for me. It wasn't for you.
It was mostly because she turned into a rapid rehousing from a relocation. So you know, and you know, the 2, I get they're totally separate. And some allowable costs are the same and some I'm not quite sure what are. That's why all my questions came, you know, the moving van and all of that. But yeah, another time for that, I guess. And I'll reach out to my rep.
Definitely do that, because I think that will probably trigger them to reach out to us, and we'll end up reaching back to them, which I know is a weird game of phone tag, but it'll probably get us to the right answer for your specific question, because it does sound nuanced. And as I mentioned before, homelessness prevention, rapid rehousing look the same as far as what they can do, but not who they can serve. And you sound like you have someone that has been served in different circumstances under each component, which just makes things go look weird that we have to talk about. So
yeah, thank you.
Okay. Any other questions? And to answer Samantha's question, if you're asking questions about annual ESG, you want to reach out to the ESG reps. If you want to ask a question about ESG-CV, you'll be reaching out to the grant administrators. And Kristen is answering that right now, so I do not need to do any more on that. Any last questions? You're able to come off mute if you'd like. Okay. Seeing none, I want to say thank you. We had 70+ slides to get to today. We wanted interaction. We got both. I hope this was as valuable to you as it was to us. I want to thank Mike Thomas and Gordon Levine for presenting today, and Kristen Delkamp for keeping all the technical stuff going, and all of you for being here. So thank you for attending this California Housing and Community Development Community Workshop offered through the Emergency Solutions Grant, Coronavirus Relief and Consulting Staffing Services Contract. Look out for more information on the next new and non-traditional provider workshop series. A short 3-question survey will pop up as this session ends. Please provide your feedback so that we can ensure that these training sessions are as useful as possible. Enjoy the balance of your day. Be well.